Sugar.
Woo wee! What a beautiful birthday that I had. I had a beautiful birthday, man. It was so much fun. I got so many other videos and stuff that I haven't even finished putting together, but I will drop them. I guess when I feel like it. You know, life is about, man, just taking care of business, relaxing, having fun. After business is taken care of, get back to work. And work comes in all different shapes or sizes. Whatever you do to earn a living, get to work. And the, one of the things that I wanted to discuss today is because I got somebody sent me a link. Well, it was a screenshot and a link. I did not click on the class because I already wouldn't even waste my time. But I just want to give everybody a fair warning. Now, this may not be what people want to hear, but I now hear, I mean, I saw it from my own eyes too, so it ain't a rumor, that now people are now starting to file administrative claims dealing with federal unclaimed property now. Damn it. Federal unclaimed property. I mean, what I thought, hold on. I don't even know what the intent is now anymore. Because it's always a new way to do something now. It's always a new process. But my thing is, what happened to the finality of the last 15 ones? What happened to the arbitration? What happened there? What, what happened to the $500 million from the bank deposit? What happened there? What happened to the Court of Federal Claims? What happened there? And don't y'all find it odd that there's always a new process, learning new steps without any finality to the last 15 ones? What is going to make this new process any better than the last 10 ones? And let me just give you a heads up. That unclaimed federal property, if you're trying to come in talking about some type of trust and try to come in through the trust side, I'm telling you this, unclaimed federal property, it's not the property and what you think. And most people think the property is dealing with, you may not say it, you may not admit it, you may not come directly out with it, but for most people, unclaimed federal property, because this is based on what their belief system is somehow tied to some type of estate at the Treasury. But maybe they didn't read the government's end of the year report about their state and affairs and their assets and liabilities or the Treasury financial manual that deals with unclaimed property. If they was to read that, you would know that too requires court intervention as well, for the most part. So y'all, there's this new way of doing things, and it's unclaimed federal property. First, I thought it was mortgages. First, I thought it was monthly bills. I thought everybody's monthly bill was supposed to be set off right now. I thought there was supposed to be one big celebration and party, and everybody's monthly bills, the billing error, I thought all that's supposed to be settled. I thought there should be nothing left for people to do. I thought all the answers were had, all the remedies were had. Now there's unclaimed federal property now? I thought the whole thing really centered around discharging your debt. Now I know that you evolve, you get more information and you grow, but I thought people just wanted to live debt free and get property and assets and don't have to be responsible for it financially. I thought those were the services. I thought that is what people advocated for. But yet, there's still people who are still held responsible to their financial obligation. I thought it stopped. Someone told me it stopped. Everybody got the remedy. It was all done. There was no need. I thought it all stopped. I thought it was over with. Mm. I thought it was over with. So what it boils down to is that shit just don't work.
You're rocking with the best.
So listen, man. Listen, I'm gonna throw a little bone out there for y'all, man. All these administrative processes that people are trying to do, number one, your administrative process means nothing if you cannot prove your claim that you can win in court. Because a lot of processes and claims that most people are trying to seek, the agency that's governing that process of claim most likely are not going to move unless there's a court action filed. Courts are flooded every day with claims. Courts are flooded every day with claims. Some of them win, some of them lose. Some of them get an appeal, a ruling that they think the judge got it wrong and they appeal, and then they go back and win on appeal. But the standard of review test, the measure is, does this claim or this process or this procedure that they're totally advocating for, does this hold? If the agency was to say no or disallow the claim, what are your next steps? What's the next step? Where's the next angle that you take them into? What's your enforcement? And most people, are they going to tell you just to double down and triple down on more administrative documents being just scattered everywhere? I know that most what they have to do first. Now, let me tell you this. If you believe that you have to change your nationality to benefit from laws that are in favor of American citizens and come in as a non-American citizens to benefit for the laws that were created solely for American citizens, let's ask yourself a question. Am I thinking logically, or I'm just following blindly? Or do you have to set up your own tribe? Hmm? Because the way I look at it, and the way the professionals, when we talk, it all seems that at some point you're going to have to present your claim in court or argue your claim in court. Just like when they want to come take your house from you, What do they do? And this is assuming you're in a judicial state. When they want to come take your house from you, what do they do? What do they file? Don't they file a lawsuit against you to get the judge to award the property? Now the question is, now the filing of the lawsuit, that's not the problem. The question is, it's not even the issue. The issue is, what is your response going to be when they try to take your home? Which Apologize. I had to take that call. But yeah. So what I was saying was I feel sorry for a lot of homeowners out here, car owners out here. I really, and put all jokes aside, I'm not even trolling right now. I actually feel scared for them. And I'm not trying to some fear mongering. That's not what it is. But I'm just because I know that times are hard. They're jacking the interest rates up. As y'all can see, the interest rates are the highest they've been since the recession. So I've been saying this since October of last year that this is nothing but the calm before the storm. Oh, avalanche is coming. Let's just remember when politics are involved, they don't care about the best interests of the people. They will sit there and manufacture a recession just to prove a point at the ballot box during election time. And midterms are coming up. It's a lot of things that's going down that which may affect you positively or negatively. Now, in recessions, most people panic, while some people in recessions they find a way to capitalize off it. A lot of people become rich in recessions. You want to know why? Because they buy low, hold on to them. When the market increases, leverage the value. Actually, the best time to buy is in a recession, to be honest with you, because your the fair market value of the asset you're buying is not going to be nowhere near the cost. And remember, it's not about actually having money. See, this is another thing with people in these spaces. We have to understand that in order to navigate in these spaces and even get the slightest victories, it starts with your mindset. You can't come in this space with acting like a debtor, thinking like a debtor, believing like a debtor, consumer, and expect to have creditor outcomes. And it's not about actually having money when you learn how to leverage capital. Now, I'm not going to sit here and tell you what you actually have and what you're entitled to from an accounting standpoint, because I feel like I'm going to have to break it down so in so many different blocks that, to be honest with you, those are for my paying clients. Like I'm be honest with you, that those they get that treatment. So I'm not going to break it all down here live, but I will say this though. I will say this that the difference between you having or believing that you have or believe that you don't have, it all depends on how you look at your financial situation. Most people look at their financial situation only from what they could see in their account or what they can get an idea of what they got coming to them on a weekly or bi-weekly basis. A lot of people don't look at their financial situation as to what they're actually entitled to, like actually really add up their receivables. Because remember, the right to receive payment, that is, as Mr. Witherspoon said, a license to print money. Remember, in order to for me to ever give you a loan, like a traditional loan, I would have to fund your purchase price out of the assets reported on my balance sheet. See, I would have to fund your loan. Financial institute, they would never do that. Why would hold on and listen, just start thinking like them. But if you don't know how they operate, how can you think like them? Like really, most people have no clue on how this financial system operates, but they all want to be teachers. Have no clue. And any information they give it out, I swear to God, you're gonna hear from the same 20 other gurus. You're gonna hear the same thing. Most people, not for real, they don't have a clue of how the financial system works, but they all want to give advice. So this is why I don't teach people how the financial system works based on how I see it, how I believe, how I want it to be. Nah, straight directly from their mouths. And then I say, this is what it is. It's not what I believe. It's not even what I want it to be. This is just what it is. And if they already set a standard of rules that you have to pass for your claim to pass the sufficiency test, I don't give a damn if I believe the total opposite of what the rules say. I'm going to follow the rules. Because remember, the object is to play the game. But you play the game to win. You don't play the game for anything but winning. People play the game all day and every day, and they don't even think about winning. Because for real, most people don't even believe it's actually true. Most people don't even believe I could sit here and drop I can put so much just information and data, and most people will still reject it because it doesn't comport with how they believe it goes based on the years of them being sold a false understanding. That's why one of my video a few months ago, I said, are your claims rooted based on the legal standard or is it rooted on a belief system? Because if your claims is rooted from a belief system, there's nothing anyone can tell you. If your claim is rooted solely from a belief standpoint, you feel like every time you submit a document, you're supposed to get remedy. And if they don't give you the desired remedy, now they're trying to block your rights. I mean, you ain't that important. I ain't that important for them to be blocking your rights. Yeah. But that was the sentiment before my client reached out to. That's what I'm saying. Like, y'all, listen, I'm trying to tell you. I'm trying to tell you. There ain't nothing like the Supreme Elite team. Like, I'm literally, now I'm not even trying to, like, I swear to God, like, the type of professional team that I have behind me, like, I, I, I don't even take that lightly. I don't even take that lightly. I don't even take it lightly. Like, I can literally get on the phone, call my securities broker, bam, literally, as an attorney friend, that's actually his friend. So anything I need to find out or get some understanding on, bam, hey, bro, ask him this. Comes right back to me. Yep, he says you're absolutely correct. Yep, that's the proper interpretation. Yep, that's the. Listen, we on the legal standard all the way. And the reason why administratively that should not be the only repertoire, and I'm not saying totally abandon it, but I will say this: that these administrative agencies, let's take the IRS for a second. They are so arbitrary and so inconsistent that it's it's hard to gauge. Listen, y'all, if you really understood the origins of the IRS and how they operate, you would know that sometimes, well, most of the times, they are not going to follow the rules. They're not going to even follow their own regulations that they set forth. But a lot of people are coming out here saying that, hey, the IRS is your friend. They're not your friend. The IRS is not your friend. Do you know what the assumption is when you file a 1040? The assumption is that you're going to be paying taxes. There's no fucking large refunds on a 1040. They're automatically going to scrutiny it from an arbitrary standpoint. There's no fucking $300,000 withholdings on a fucking 1040. That don't even, and this is the problem. We never look at it from how they would see something like this. It's never fully substantiated. It's never for, I guarantee you, most people who submit 1099s don't even understand the regulations that govern the form because it's already confusing. It's already complex as hell. Don't even understand the regulations. Don't even understand what's even in the instructions. 1099A, abandonments and transfer. I mean, abandonments of property and acquisitions. That's it. Abandonments of securities and acquisition. That's it. That's it. But look how they had everybody feeling the 1099. Like, remember the 1099A first hit? I mean, it's real old. It really started busting onto the scene about 2006, 7, 8, 9, and it had a resurgence in the 2015s, in the 2000 teens, had a resurgence, and it had everybody out here setting up a 1099 online account, got the accepted. The only thing it means is the IRS has pretty much received the submission, or sometimes when they don't accept it, they'll reject it because maybe, hey, the social security numbers don't match what's in the system, or this number is off. But it being accepted had nothing to do with that. They was automatically going to generate a check from that accepted 1099A. And when I first told people about this 3 years ago, they all jumped on my back saying I was an agent, or I was trying to discredit, or I was trying to do this. But you check back in 3 years later, that 1099A from 2022 20 still says accepted, but nothing has happened. Hey, some people are just looking for a quick come up using this process. I get it. Shit, I don't blame you. It's hard as a motherfucker out there. It's hard out here. You got to go get it every day. It's hard. Cost of living steadily going up. People losing their jobs left and right. Everyone who's claiming they so independent, damn sure ain't feeling this new, this what's going on lately. And I have a feeling that a lot of people are going to be in a position where they're going to get foreclosed on, or have to answer a suit for possession. And when that time comes, it's better you to be on the right side of the understanding and then on the wrong side of it. Because the and I'm just going to sum it up. Everybody's trying to liquidate their interest, set off their debt. So I'm going to assume that, okay, you're going to court eventually on your claim. That's just no, you can't administrative your way to the top. You're going to have to go to court, because I would rather you look at it like that and then hang on the fact that maybe 1-2% may be able to set off the debt out of court. Maybe. And if you want to place your odds on those 1-2%, be my guest. But the reality is you're going to end up in court. There's just no other way around it. Whether you're filing bankruptcy to stage them off to get that automatic stay, or you're responding to a claim, or hell, you may be bringing a claim in, as the plaintiff. But you're going to court. Because if you think these people that are part of a $16 trillion a day industry with derivative securities, MBSs, ABS, CDOs, if you think that they're going to get your letter, your instruction, your notice, and say, all right, we're going to set off the debt based on a law passed in 1933, do you really think they're going to do that? If you believe that and your teacher has gave you the reassurance that that's going to happen, by all means, be my guest, pursue it. I wish you the best success, and I want you to send me an email of the set off, of the satisfaction of lien, of you getting the so-called title back to the property, and I'm going to have a live, and I'm going to eat my words right in front of you. And then I'll walk everything I said back. And I've been putting that same offer out there for 3 years, and no one's made me eat my words yet. But what I have gotten is letters from the mortgage company responding back to the notice and the letters and the claims that they did. People, yeah, the letters they got back that's telling them to refer to these court cases where the courts have deemed claims as similar as yours as frivolous. I've gotten a lot of emails saying that. I've gotten a lot of emails and talked to people on the phone when they sent that certified funds draft to pay off their mortgage. Soon thereafter, they got one of these. FBI telling them, hey, don't do it again. Oh, I got what, 5 people I've spoken to that's happened to them. And what were they trying to do? They were trying to get out their obligations, set off the debt. Okay. See, there's a social media way of setting off a debt, and then there's a legal standard way of setting off the debt. Ask yourself, which way seems more valuable? Like, if I didn't know what was going on, what the hell would I do? Would I trust the social media way or I trust the legal standard way? I don't know what you would do. I don't care. But I'm telling you this. I'm telling you this, that whatever you're trying to do, whether it's a credit card, consumer loan, student loan, foreclosure, repossession, or hell, they already took the house, or even if they took the vehicle. If you cannot style your claim, put it on a motion that passes the standard of review in a legal way, you are going to be handicapped to the administrative process forever. Then from there, it's a hit or miss. And most administrative claims are settled after the claimant actually files a suit in court. See, they'll then come and settle with you out of court and they do a joint motion to dismiss the case. But unless you can prove that your claim will win in court, they're not really going to take you serious. That's just the reality of it. Like, some of them are going to make you go to court. Banks, financial institutions, best believe that they're gonna make you go to court. Or they're not just about to settle uh, uh, just off your letter and your notice or that package you got. Oh, they ain't settling. Because why? Listen, it's a $16 trillion a day. Why would they have to? These people pay high-powered lawyers to protect their system. Why would they just settle with you instead of making their lawyers do the work? And regardless if your claim you presented to them is spot on, their job is to always deny. Their job is to always tell you, hey, it's wrong. Hey, it could be right. But their job is to tell you, yeah, yeah, that's what I'm saying. I don't know why people believe these teachers, like they know these lawyers, like they're connected to their transactions, like they could predict everything that's going to happen. No one can predict. No one can guarantee you 100% win or 100% of the times on 100% of the claims you submit. Like, yeah, I know, even in the paternity test, it ain't even 100%. It's 99.999%, meaning the likelihood of this child being someone else's is slim to none. But it's never, this is 100% your child. This is the likelihood of this being anyone else's is virtually impossible. There's only one way to win. The type of claims that everybody's putting in, because to be honest with you, the claims that people are putting in, like the administrator with the IRS with the tax forms, I'm going to translate that to court. Those claims that they're trying to do is just remove the debt, so they don't have to pay anymore. That's all that is. That's all. But that's the gist of it. They're like the true capacity which they need to be coming in. how to style a motion, how to make the proper arguments, how to make sure your arguments pass the court sufficiency test, how to state a claim upon which relief can be granted, and then case citations where court cases have ruled on claims similar to yours in their favor. That sets a precedence. That's a good thing to have case citations because it helps the judge see the picture clear and say, hey, Your Honor, in this circuit, this case is similar to mine, virtually identical to mine, and the courts all ruled consistently in this way. Because one thing that they can't do in the state and federal courts is have too many inconsistent rulings. The courts have to be consistent. So if there's that one controlling case, meaning the courts took up this is the first time the courts ever hearing this issue. However they rule on that case, that is going to be the controlling case. So every case that comes after that, that's similar to that, the courts are bound by that precedent. So it's more pretty much cut and dry with the courts. The only thing that is not set in stone is the arguments on the other side, how the judge is going to interpret the ruling. And this is why we use controlling cases. Why do we use controlling cases? Because the controlling case pretty much sets all interpretations to the side. The judge can't interpret it different from the precedent. And if you don't have legal court cases back in your claim, you are going to be on the spin cycle with these agencies for as long as you can stay on it. Because even with the IRS says, hey, if you don't like this, you know, you can file a petition in the tax court. But what is the IRS always saying if you don't like it? What do they say? Hey, you can appeal it to court. What they say? If you don't like it, take us to court. That's pretty much what they say. If you don't like that we disallowed this credit, take us to court for it. And this is why a lot of people are so hung on administrative claims because they don't know what to do if the administrative claim doesn't work. And this is why they jump from process to process, trying to find the square peg in the round hole because they know they lack the ability to actually take their ass to court. Remember, I didn't start off with finance and stuff like that. I started off with court cases. I started off doing legal work. That's how I started off first. So courts, that's right up my alley. State and federal. State court, federal court. Now, state rules a little different. So you just have to learn the rules to the state court. Learn it, and that ain't nothing because they might be a little different rulings, but it's all gonna be the same principles. Ain't nothing. Like I said, I'm in litigation right now on two different fronts. And litigation literally right now. My client had court today, this morning. Foreclosure was removed completely off the table. Now we are in a chess match. And I'm the point of contact for my client. And then the mortgage company's lawyer is the point of contact with them. And she came out and said, all right, I'm gonna go through you. Because yeah, so are they being represented by legal representation? I said, no, they're not being represented by legal representation yet. I'm just their power of attorney. So I'm just, on standby advising them, as we proceed. Said, okay, so I'll just go with you. Hey, here's the stipulation here. Have your client sign the da. Then we'll do this, then we'll do this, then we'll do this, and we'll do that. And literally been negotiating with him like she literally she's been treating me like their attorney. Literally. And now we're in the chess match. But one thing that is not going on right now is a foreclosure. because I know where it's going, and I know that they don't want it to go there because we never style our claims based on what any teacher, including myself, tells you what you should style it on. You should never file any type of claim based on what any teacher says unless that claim blank, 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 blank. When these teachers have these classes, are they doing legal case citations? Are they pulling from material publications from the top attorneys in the world that's dealing with the claims that they're talking about in the class? Just like old girl with that mortgage, that auto contract class, right? That I reviewed. Was there any legal interpretations that she cited? Was there any like document of publishings from the top law firms in the world, even top contract law firms in the world that was mirroring what she was teaching? Was there anything outside of her singular interpretation on what to do? Was there anything that she presented outside of her way of seeing it? Who knows if she was interpreting it the correct way? What case citations did she cite that the judge ruled in the favor of a consumer that was identical to the claims and the way she's saying pursue it? What case citation, what legal standards did she present that told you to put that stamp, that verbiage on the stamp of the back of the securities? What anything did she show that says that that's what you're supposed to do from a legal standpoint, not from what her, because this You know that's all it takes to get a revenue ruling. You I don't know what's going on with the Wi-Fi has been crazy. I know I pay my Wi-Fi bill. I think it comes standard with the. I think it comes with with the. I got Verizon by the way, so Verizon may be some shit. Verizon, I think Verizon some shit. I got the whole what they call it the high octet speed. Yeah, whatever. That shit still be buffering. It still buffers, but what I'm trying to so and I know only certain people reach out to me now. The ones who get triggered by what I say because I'm talking about the same claims that they did, and it's like they're taking their frustration out on me because the same claims that I'm talking about. Let me see. How about now? Yep. All right, that's cool. Yeah, that's cool. So let me go ahead. Let me go ahead and do this. Let me go ahead and do this because that tsunami is on its way, and you ain't gonna be able to administrate your claim, and you ain't gonna be able to just administrative claim your way to victory. Even in your auto contract, remember what they tell you in your auto contract? Any recovery here under, remember? You know what they're telling you? You got to take their ass to court to win in your auto contract. That's what they saying. That's what they saying. Remember, any recovery will be limited to what you actually paid, something like that. Remember that? That means they gotta take you to court. I mean, you gotta take them to court. That's exactly what it means. And the reality is, they never taught you how to win in court. That's just the reality. They never taught you how to win in court. That's I'm not trying to be funny. No, I swear I'm not trying to be funny. They don't know how to win in court. That's why everything is a administrative, just straight from the administrative point of view. Everything is administrative. So what I'm gonna do, we're gonna go back in time. I think this was last year. I'm not sure. I think it was last year. I think it was last year. Let's go back in time.
For being enrolled in the customer portal. So how may I help you today?
Okay, I'm calling because I have a question. Now here's the thing. It's the part that I'm going to say. This is the part. Everything that I'm talking about now, if I had to take them to court, everything that she may admit will be a part of my argument. Everything that she will admit as true will be a part of my argument. What's up, Darren? Everything that she admit as true will be part of the argument. Supreme Elite Team, we got class and we got class tonight too, y'all. We are going in tonight. We are going in tonight. Everything. So let's see if we can widen this screen and get to it. Regarding the actual
Hold on.
Let me go back to the beginning. There we go.
For being enrolled in the customer portal. So how may I help you today?
Okay, I'm calling because I have a question regarding the actual the contract. I have two questions regarding the contract and the down payment. Now, before I would just like to let you know that I did. And the down payment, that's all part of the claim. But you gotta play the game to get that contract. Now you can execute while within the game. But the down payment, it's just part of the claim. It ain't even the biggest part of my claim. It's very minute. Because obviously, it's, it wasn't a big factor of me. I'm not gonna sit there and argue them down at the dealership for about the contract. I mean, down payment. I mean, I want hands on the contract. So now when I step into that venue, it's just another nail in the coffin for them. Another order that can be ordered in my favor. I did talk to the dealership prior to signing the contract, and I talked to the dealership with my inquiries afterwards, and they've told me to reach out to credit acceptance because this is why it's good to understand the accounting and how they account for these transactions on their consolidated balance sheets. Oh, when it comes to the accounting on the actual bank examiner's level, nobody in this space is touching the Supreme Elite Team. Nobody, no teacher. You could bring, if you can bring 5 of your best teachers, and it'll just be me. And I guarantee you, I'll ask them all one question, and I guarantee they won't know the answer to it. And you have to, only people that's going to know the answer to that question is the people that actually are on that side of the fence. Or unless you're in the Supreme Elite Team. Because on their consolidated balance sheets, it's going to evidence a loan, not from credit acceptance to the customer or consumer, but that to the dealer. That is important when it comes to actual liability on the account. From them. So if it's a loan from the finance company to them, why do many people try to keep talking about discharging the contract? Why is discharging the contract so important to people? Listen and listen carefully. Anybody who's teaching, advocating to put a verbiage on the back of the contract or discharge the contract, trust me, y'all, they have no clue to what's really going on. Trust me on this one. To me, it was a loan from credit acceptance to them, in which part of me purchasing the vehicle, it was they assigned the loan over. Now, that's important because last time I spoke to credit acceptance employees, they told me to reach out to the dealer, you sign the contract, but it's evidence that the contract is generated by credit acceptance. So it's under their approval. So my first thing is the down payment. Now, on a recorded conversation with the dealership told me that the credit acceptance. Now, although I'm phrasing all this as questions, I know the answer to every question I'm asking. I already know what went down from an accounting standpoint, from a security standpoint, from a trust law standpoint, and I can evidence this in court. And I have case citations where cases similar to mine, the borrower, so-called borrower, one, I got the disclosure, the regular, I got everything down pat. The only thing that I'm calling here is just to see what she's going to say. She could have confirmed or denied it to the cows come home. It wouldn't have knocked me off my square because I already know what's going on. And I'm not talking about knowing what's going on from the time the contract is signed and executed. I'm talking about before I even stepped into the dealership and post-transaction. I every step, I know what's going on. Would approve the financing, and I will make a down payment in order to seal the deal. I asked the dealership, are you pocketing any of this down payment? And the dealership. Now, why do you think I asked them that question if I didn't already know that they would? See, it's not enough to take that soundbite and be like, oh, dealer, yeah, you're pocketing it. How are they pocketing it? How are they accounting for the down payments on their balance sheets? See, this is the boring, time-consuming part of the game that most people will avoid. So it's easier to put a verbiage about securities that only apply to securities issued directly from the Treasury, United States Treasury, on the back of your contract and send it in to the indenture trustee. See, that's quicker and faster. It don't take no understanding. You're just following steps. But it's actual getting down and dirty, the X's and O's of it. Most people want to stay away from it because they don't have the patience. They want quick, fast results. Said, no, it's going to credit acceptance. Now, before, and I ain't gonna keep stopping it. Be advised that anytime you're pursuing any type of claims in this manner, it could take anywhere from 6 months to 5 years for its resolution. So all this 60 days, maybe a year at the most, it's over when it's over. Now, I looked on credit acceptance filings with the SEC, and the credit acceptance did this with the dealership because I'm under the portfolio program, and the dealership has already said they don't offer in-house financing. This is why it's always good to already do your thorough research before you call them. So there's no question about the transaction that you're under. You don't need to call and see if they're going to verify what you believe you already know. And this would lead to frustration because we're looking for them to validate things that they don't want to and not. That is a bar. That is a bar. And believe it or not, many people will take what the teacher said in class and call the financial institution hoping that they're going to validate what the teacher said when they're on the opposite side of they're against you. And most people think that if the bank don't come out and validate what you're saying, then you might not know what you're talking about. That's a fact. I don't know why people think like that, but that's just the mindset of these spaces. I'm going to. Notice how I told them I was under the portfolio program and there was no denials or words said because remember, I told her what program I was under. I told her. I didn't guess. I didn't ask her what I was under. I told her. When you know what transaction that you're under, you can be assertive. and keep the conversation going instead of being uncertain and looking for validation from people who have no interest in validating anything that they may potentially be liable for.
A down payment from the customer, a cash advance from us meaning credit acceptance, and after the advance balance, um, net collections and the cash payments made on the consumer loans and costs and our servicing fee. It also revealed that credit acceptance is the servicer for credit acceptance auto loan receivables trust. So just to give you a little backdrop, the money was provided by investors in the trust, and it was secured by my monthly payments of principal income.
That right there kills every class talking about discharge the contract. That was the legal transaction from the accounting standpoint. That's the accounting. I'm sorry, let me take that back. That was the substance of the transaction from the accounting standpoint. The actual contract and indebtedness, that's the legal characterization from a contractual agreement. Why would you ever try to take any action to discharge the contract using contract law when they're using contract law to stick you with the debt? Man, oh man. Supreme Elite Team, y'all are in that group for a reason because
You're rocking with the best.
So every time I make a monthly payment on my vehicle, it's not going to credit acceptance to pay down the loan. It's actually going to the investors who purchase trust notes from credit acceptance trust. And that principal interest payments goes to pay down the trust notes. So my question to you.
Damn, hey Darren, bro. They don't even get it. I told you, Darren, what'd I tell you, bro? My shit be the shit that I give away for free is more valuable than 10 of these so-called gurus. 10 of these so-called gurus combined. If they really understood what the hell, they only understand that I really, from a legal accounting standpoint, really just let them know all what they did pursuing the contract was futile. Everything. Broke it down. But you want to know why it went over a lot of people's heads? Because I'm speaking from a highly advanced accounting standpoint. Because I'm not just saying it. Y'all know what the professor said. The professor said, yeah, this seems like highly advanced accounting. Like this is you don't even learn this at school. This is on the job training. You'll learn this in a manual put out by the FDIC, or like if you're a bank examiner, this will be a part of your training packet. Knowing how to mark these, knowing how to account for these, knowing how to characterize the transaction. Like you don't learn all that in school. You learn that depending on the position you get.
First, how is that the dealership is saying that the down payment went to credit acceptance in the beginning? Then when I called them back, they never admitted that they said the down payment goes to credit acceptance. They forgot they was recorded at the time. And second, that credit acceptance, in their own words, in their own filings with the SEC, it says that the dealership receives the down payment as part of payment for the vehicle. So if I needed to pay $2,700 to amortize the contract, to finalize the deal, and I
don't even know it, amortize the contract. They don't talk like that in a regular space. That's highly advanced accounting back office language. You know, average person know what that means? They don't know what that means. What does that mean? That's what I'm saying.
it was disclosed to me, and I have a recording of it, that the money's going directly to credit acceptance. But then come to find out, credit acceptance never got that $2,700. The money also went to the dealership as part of the payment for the vehicle. So my question with credit acceptance is, how does that $2,700 end back up with the dealership when it was presented to me that the $2,700 was going to you all to cover the deal? And you know how I know that was bullshit, that they was going to keep it the whole time? Because the first, they gave me three numbers. They gave me 5,200 and then 4,800. 5,200. I said, man, fuck no. Then 4,800. I said, nah. Never, you know what? Never mind. Oh, let me see what I can do. Let me see what I can do. And it came back like, all right. They said 2,700. You see what I'm saying? If that's what they really wanted, they gonna stay there at the 52. Man, I said, fuck, because I already knew, man, y'all keeping, I mean, in my mind, y'all gonna keep this anyway. I could talk y'all down. And they went back the third time, like, all right, we could do it for that. Yeah, y'all ain't about to work. Y'all ain't about to over. Fuck no. I already know what y'all doing anyway. Nah, that shit is totally negotiable. Literally, they throw me three numbers out there. And we settle for the lowest amount. It's all negotiable. But how people get trapped is they don't have the confidence, and they're so scared that they're a little intimidated by these financial people. When you're sitting there at the dealership, they're a little intimidated. I'm not intimidated because I don't walk in there with intimidated. I literally tell them what they're going to do. This is how it goes. So let's try that with someone else. Let's not do that. Not here. You got about 100 people that's going to walk in through this door between now and tomorrow. Y'all going to get every single one of them hook, line, sinker. And they come back playing, all right, we ain't going to do that. But yeah, that's, I'm telling you, man, understanding is more valuable than knowledge. This is a tactic that every good trial lawyer uses. They ask questions that they already know the answer to, and the person that's being cross-examined or on the stand, they know the answer as well. And you ask the question which you already gave the answer. We already gave the answer to the question. So we asked them just to see if they're going to be honest. And when you put them in a situation like this, they have no choice but to tell the truth. And as you will see, or hear rather, that she has no choice but to tell the truth. Shall we proceed?
So what you stated is correct.
What you said is correct. What you said is correct. When I transfer it over to court motion form, it's a part of my claim. So when their lawyer gets it, what do you think? How you think they're going to respond? What do you think they're going to say? You think they're going to be like, nah, Your Honor, he has it wrong? And a lot of this stuff, when it comes with these claims, it has everything to do with how can I win in court?
You will see, or hear rather, that she has no choice but to tell the truth. Shall we proceed?
So what you stated is correct. So the down payment actually goes to the dealership to help qualify you to get the loan. We don't collect it, the dealership does, but it is a part of your loan. So we don't get the down payment.
I didn't even need her to say that. I already know.
This is why Thomas Legacy Equitable Solutions is valuable, because we ask the right questions and we get the right answers. I did all my research to already know the answer before I even called these people. And that's the problem. You got people just doing what other people say, not really understanding what they're doing, don't know how to communicate, and then they get mad at the results that they get. This is why it's important to put sufficient time and research into this, so you know what you're doing and they know what you're talking about, so they're not going to play these type of games with you. But
now, I didn't have to send them a letter in and them confirming it on paper. I didn't have to see anyone, oh, I'll get you out your down payment, because I have to see no one else's success. When you study and you research and you acquire the understanding, you don't need to see anyone else's result to validate yours, or before you move, you set the tone. You don't follow other success. We want to become the success that others follow.
have people with little experience in these fields giving advice like they're experts, and people are taking what they say on face value. You just heard it, not from me, from her, confirming what I already know. So how do you think this looks when I file the tax forms? When I look at these amounts as already paid as taxes, how do you think it looks? Do you think they can argue that? This is why my group is valuable, and these are why the rates are what they are.
And I'm going to raise you on the tax forms. I'm going to raise you. I'm going to see that tax, and I'm going to raise you. You know what I'm going to raise you? I'm going to evidence this in court. Can you win in court? Because the IRS issuing a refund doesn't necessarily mean they agree with your position. I'm just going to be honest with you. Sometimes they just got too backed up and they get you out of their head. They ain't got time. It looks sufficient enough. But I'm going to raise you. Who can actually pull this off in court? I'm going to challenge. I'm going to challenge myself. Can you win in court? Because that's the ultimate test right there. A court order saying you win, that is the ultimate. That's above any IRS refund. That's above anything. Can you actually win in court? That's the highest standard. So I'm going to raise the taxes and head to court. I'm going to raise you one. I'm going to go above and beyond.
You want top-notch quality, you need to. This is why Tom in this instance says they don't. That's very important. Now, the actual loan is, I want to refer you that the dealership in this instance says they don't offer in-house financing. So how can the dealership give me a loan when they don't give out loans?
Gotcha. So in-house financing is like it's the dealership. If you borrow the money from the dealership, or like when the dealership, you do your paperwork, like you're making the monthly payments to them. So because that particular dealership doesn't do their own financing, they reached out to other financial institutions who do. We are one of them that accepted the loan contract.
Okay.
That's why you wouldn't make your monthly payment.
Bam! Got court cases. Got court cases where the courts have saw through that, saw through the form of the transaction and looked at the substance, saw the form of the transaction and looked through it and found the substance. Man, oh man. Sheesh.
To the dealership, you would make them to us because we provided the loan.
Now, I didn't bust her wide open when she said she provided the loan, but I am going to get her to contradict what she said. 10 minutes, 4 seconds. She said, because we provided the loan. Okay, now watch this. Now, I don't need to sit there and go back and forth with her at this part saying, no, you didn't make the loan. You didn't make the loan. I'm looking at all the evidence I need. See, most people are hotheads. They get too emotionally involved and they think that they're being lied to and it's insulting their intelligence. You got to remember, this is litigation. You see it this way, they see it that way. You don't get well, you're wrong, because I'm looking at it right here. Why are you looking at it? That's what most people do in these spaces who are really uninformed about not just the X's and O's, but how these people operate.
And this is really, and what I said was very true. It's litigation. We see it one way, they see it another. We have to get out this mindset thinking that they're automatically or always supposed to see it our way just because we put it on paper, just because we believe it's true. That doesn't mean they're just going to still see it your way. That's why we have adversary courts to handle cases and controversies.
How they're trained. This lady doesn't know nothing about the AK 10K filings. So why am I going to try to educate her on something that wasn't part of her training manual? She goes by how she was trained. She's not going to take my word. And that's what most people do. They get into these bar fights over the phone with them. They get frustrated and then they wonder why they get nowhere when they're on the phone with these people. I get more over the phone with these people than most people get in writing.
All right. Facts. Facts. Facts.
You're rocking with the best.
Facts. Facts. And y'all notice, right? You ever notice? Do y'all notice how you never hear them dropping calls like this? Calling these people. You notice the gurus, they never ever drop calls like this. Because everything that's in this call is the stuff that I went over in my class, what I teach. Why don't they put their, they never drop calls. Why don't they drop calls? They teach it, right? Drop calls. See how it plays out, how it sounds. Give the people a little visual or something they can hear, they can see, okay, so I can see it could go this way. So that's cool. Thank you. I appreciate that. So, she wanted me to get off the phone right then and there. And I was like, I got you here. You're going to stick around for a while. Go grab a Snickers. What I have here is coming from Credit Acceptance's own mouths. It states that when they do their accounting on their balance sheet, the back office stuff, it states that on their accounting, on their books, that is going to be reflected. Matter of fact, page 55, it says, for accounting purposes, the transactions described under the portfolio program are not considered to be loans to consumers.
You're rocking with the best.
So you notice how she said, we the ones that gave you the loan, because they trained her to believe that. I'm not mad at her. I don't think she just purposely lied to me. I know she ain't purposely lied to me. She don't know. I ain't about to take it out on her. She don't know. She don't know for real. But this is what I'm trying to tell y'all. Y'all be taking these classes from people that's so centered on the contract when you're not even legally obligated on it anymore after you sign it. It's fruitless. Why do you think we do things from a highly advanced accounting standpoint in the Supreme Elite team? Because the highly advanced accounting standpoint is the substance of the transaction. I guarantee you, the way they represented the contract to you and how the transaction went, when they go do their accounting for it, accounting for the cash inflow from your monthly payments, your periodic payments, aka cleanup call, when they account for it, I guarantee you, if you was to be in my group and we bust open the books, you're not even going to see a loan from them to you, which they admitted from an accounting standpoint. Everybody's contract law, trust law. What about accounting, advanced accounting? Because if you don't understand that, you're not really going to ever know what's really going on. Instead, our accounting reflects that of a lender to the dealer.
And if you so happen to inform them of the true nature, you just, hey, this is what y'all say. This is not my position. And read off what they say, even though you know they're still not going to know. But you're just getting it on record. You're just planting the seed. And you're doing that just to let them know, like, hey, you're telling me this, but I'm actually going by what your own policy says. So that if you want to enlighten them in that manner, you just, hey, this is exactly what says out of your own mouth. So you are making a point that even though you're saying this to me on the phone, whoever does your books are saying this. That twists them up. But you notice I'm not going to be like, well, you're wrong, you're wrong. I just say, hey, okay, well, your own accounting and credit acceptance, they say this. So I just use that to contradict what she's saying, and she don't even know she's being contradicted because she doesn't know nothing about the AK 10K filing. So I said that and I just left it alone.
And here's the thing about AK 10K filings. I don't know. Oh man, it's just so many mistakes I see people make on the daily, following all these popular gurus. An AK, a 10K filing cannot be used as evidence in the court. Because number one, we're not a party to those agreements. So you really can't use it as any type of enforcement claim. You can only use it to paint a picture, to point out contradictions between the form, which is the contract, which everybody seems to be focused on, over the substance, what really took place. And there's only one venue that, well, I'm not going to get into all that. But anyways, so basically what I'm saying is the AK-10K, you can't just print it off and attach it to your court case and be like, all right, you're on here because of this. I'm entitled to this. That's lazy work. Just like you can't attach an auto or mortgage securitization to your court filings and be like, all right, because of all this here. No, you got to take bits and pieces from it and incorporate that in your claim and paint the best picture. You can't just take the whole thing and be like, all right, all because of this, I'm entitled to this now. It never works. So, it further goes to says that this is what took place, man. I signed the contract. Now, notice how she said, go back 10 minutes, 4 seconds. We're the ones that provided you the loan. But notice how now, notice how this, I'm basically going to tell her how it went. Now, she already said she gave me the loan. Remember that part. She already said they gave me the loan. She already said it. Now I'm about to say, no, ma'am, this is what really happened. Oh my gosh. Come on, they can. Oh my gosh, who can pull that off?
You're rocking with the best.
Who pulls it off like that? Third goes to says that this is what took place, man. I signed the contract. The dealership transferred that contract to credit acceptance. Credit acceptance now had the proper collateral so they can issue trust notes to the investors. The investors put the money up for my dealer for the purchase price in exchange for the contract received.
And I'm only doing this just to let her know that I know what's going on, because she doesn't know about the AK 10K filing. I'm telling her in an assertive manner, like, all right, man, I heard what you said, but this is what really happened. And I'm doing this really to educate her. But it was just more than just to let her know that, okay, this is how I see it.
In which where I will be making my monthly payments. Cool. No issue with that. Because I didn't want to spook her. When I say cool, no issue with that. Because I didn't want to get off the phone. Some of y'all be spooking them. Because y'all, like, you come off like you trying to catch him in a trap or something. That wasn't my intent here. And I wasn't trying to throw her under the gun where she was just going to start dancing around now. You feel me? Y'all give me 1 second. Who said that Lil Wayne album was trash? They tripping. They tripping. A few beats could have been different, but who said that Carter 6 was trash? They tripping. Let's get back to it. I'm about to tell her how it went. The thing is, and your legal department admitted that credit acceptance never gave me any type of funding. Now remember, sorry, y'all, let me go back in. Remember, she at 10 minutes and 4 seconds, she said, we're the ones that provided the loan. Remember in the beginning? Now I'm going to, and my thing is, no, ma'am, let me tell you how your company really did it. I'm a consumer in their eyes. So let me tell you how your company really did it, though. Making my monthly payments. Cool. No issue with that. The thing is, and your legal department admitted that credit acceptance never gave me any type of funding in order to even support a contract, which is not a big deal. Rather, they got my promise to pay, the security, and they was able to raise the funds for the purchase. So is it that credit, and this is their own words, I'm reading from the in this file with the SEC. So is it more that credit acceptance really just acted as a broker between me, the one that needed financing, and the ones who's willing to invest? But that right there, what most people don't understand, the one who needs finances versus the ones who need to invest, that's taken strictly from a legal top law firms breaking down those transactions. I got that from them. The ones who need finances versus the ones who's willing to invest. Come on, man. Come on, man. Come on, man. That's why this is only 2%.
You're rocking with the best.
Everybody follows. Everybody follows the wide path in these spaces, and only people who follow the narrow path. I'm the narrow path. I'm the narrow path. I'm the narrow path because everything I teach goes against most people's own belief system. And most people follow teachers who believe and think just like them. But if you've had the experiences in the years of a decade plus dealing with all types of agencies, and you were able to get the Internal Revenue Service to admit to your position, then these these conversations may go a little different because she knows she's not dealing with a regular consumer at this point. She knows she's dealing with someone who understands it on their level, which allows them to be honest and have the conversation with me. Now, whether she answers the question yes or no doesn't even matter because she is protected by the contract in her mind. But if she answers this question and confirms my position, then this is more evidence, and it's evidence to everybody that's listening that Thomas Legacy knows what he's talking about. He knows what he's doing. He knows how to ask the right questions, and anything that he submits documents on anybody's behalf or his own, there can never be a true rebuttal or a true denial of the claims presented, because these questions are asked pursuant to the filings I'm going to file with the IRS. So when they confirm your position, that means your position is valid when you present them to the IRS. And I'm going to raise you further. Court. I'm going to raise it further than IRS. Filing in court. I'm going to raise myself. So what is the question? They was able to rate between me, the one that needed finance security, and they was able to raise the funds for the purchase. So is it that credit, and this is their own words, I'm reading from the in this file with the SEC. So So is it more that credit acceptance really just acted as a broker between me, the one that needed financing, and the ones who's willing to invest? So you now, the answer to that question is either going to validate her position when she said that they loaned us money, or it's going to invalidate her position and substantiate my position. Present them to the IRS. In my contract. So you all just kind of mainly were just the middleman to broker the deal instead of really being a lender in the traditional sense, like credit acceptors went into their own back pocket and put up the money. So that's the question right there. Remember, the 10-minute and 4-second mark. 16:27. Refresh your memory. Refresh your memory. A refresher for you. Now, I don't need to sit there and go back and forth with her at this part saying,
accepted the loan contract.
Okay.
So because that particular dealership doesn't do their own financing, they reached out to other financial institutions who do. We are one of them that accepted the loan contract.
Okay.
That's why you wouldn't make your monthly payments to the dealership, you would make them to us.
In my contract. So you all just kind of mainly would just. Y'all hear that? For in-house.
When the dealership, you do your paperwork like you're making the monthly payments to them. So because that particular dealership doesn't do their own financing, they reached out to other financial institutions who do. We are one of them that accepted the loan contract.
Okay.
That's why you wouldn't make your monthly payments to the dealership, you would make them to us because we provided the loan.
Right? Okay. You provided the loan, right? Okay. In my contract. So you all just kind of mainly were just the middleman to broker the deal instead of really being a lender in the traditional sense, like credit acceptors went into their own back pocket and put up the money. You kind of more brokered the transaction with your credit facilities and financing capabilities. Credit facilities. That's another boy. These high end terms flying over people's heads like a fucking bird. Don't you understand? That is the crux of every transaction, every way you're able to get financing. Just flew right over the head. Capabilities and resources. Is that more of an accurate statement?
Yes.
You heard what she said? Is that more of an accurate statement? And I said that for a reason. Meaning, is it more of an accurate statement versus what you told me earlier? Or the transaction with your credit facilities and financing capabilities and resources. Is that more of an accurate statement?
Yes.
Well, I'll be damned. I'll be damned. That is a direct admission. Money. You kind of more brokered the transaction with your credit facilities and financing capabilities and resources. Is that more of an accurate statement?
Yes.
Well, I'll be damned. I'll be damned. That is a direct admission because she knows that I understand the internal accounting, the internal securitization. These are classes that these SEC instructors charge 15 to 20 grand for a 4-week course just for you to know the same thing that I know. And my 7-Series securities broker friend, he went to his instructor who deals with CDOs and mortgage-backed securities, and he confirmed that I am absolutely correct and that we are absolutely entitled to the proceeds of all the money made on the back end. She admitted it. Now, most people, when I see them calling on TikTok, then you take my money, deposit to an account, went to the Federal Reserve, they don't understand the true nature of this. This is where the frustration lies. And this is why Thomas' legacy is so important to these spaces. Okay. So no issues there. No issues. Because I didn't want to spook her. No issues there. No issues there. I got to keep her there. Love my truck. Have no issues. There's no issues there. So how would I go about the down payment, because if it's part of the loan, the down payment really should have went to the investors who actually purchase put up the money for my contract. Was the down payment more like just other types of fees and processing fees and other type of things that needed to be in order for the transaction to close, rather than it just being the down payment on the vehicle as represented?
No, the down payment is just that. It's just the down payment that you're putting on the vehicle.
Okay. Is this down payment recoverable for the simple fact that whether or not I gave the down payment, I don't think that would have had any bearings on credit acceptance accepting the contract, because it didn't go to them anyway. They really didn't have a financial economic interest in the down payment. The value right there. Right there. Whether or not credit accept the down payment was ever made, would have had a bearing on whether they would have accepted the contract or not. If you catch the underlining in that, that's what I'm saying. I have more shit that's valuable that's I put on YouTube for free than what people would pay $1,500 for, $2,000, that put out for free. I got much valuable for free. This is so valuable on so many different levels. But if you lack true understanding, this is going to fly over your head. And then you'll be reaching out for me to do it for you, which I'm cool, but you're going to pay how you weigh. Value of this conversation, and you can't even put it to words, because this question and this dialogue summarizes millions and millions of dollars in down payments, to which whether you make it or not has no bearing on if the finance company is going to accept the contract. Wow. Wow, wow,
You're
wow.
rocking with the best.
Wow. That is major. That's major. And these are the services I offer. Services that affect people's daily financial lives, because that down payment can be a couple months payment right there. This is why Thomas Legacy is so valuable. Like, as long as you got the promise to pay, your monthly payments, everything secured, you check the credit, you check the income. Isn't that pretty much wasn't a big deal for credit acceptance? Or would have been the money that if I didn't pay, would credit acceptance have to pay the dealership that amount? So it's kind of like, we're going to move this off and just as far as the purchase price of the vehicle, instead of us coming out of our own pocket to do it.
No, we actually have nothing to do with the down payment.
Once again, we have nothing to do with the down payment. The down payment doesn't come to us. The down payment, none of that. And remember, let's just say this. Before you sign that contract for that vehicle, that dealership is already obligated on it. Regardless of whether they sell it to you or not, you do the contract with them or not, they still are obligated on it. And what she said, we have nothing to do with the down payment, meaning you have no economic interest in the down payment. So whether a down payment is made or not doesn't have any bearing on whether after they accept the contract, that's it. Has nothing to do with a down payment, because they don't get it. There's no economic interest in it. The down payment is only part of the dealer's compensation for the vehicle. It's major. She just admitted that these dealerships situated across America, they have nothing. I mean, these finance companies have nothing to do with the down payment. Wow.
The down payment is strictly negotiated between the customer and the dealership. Now, the dealership may recommend a certain amount to put down in order to help you get financing.
May recommend. not required. They may say, hey man, if you put this much down, you should, but may recommend. That is not a mandate or an order in order to secure the contract. All right, but this is the only roadblock that I see with that is, and I have the recording of it. I can send it to y'all in an MP3 format, that the dealership stated that you all required it in order for the transaction to be complete. But you're telling me that y'all really didn't have nothing to do with it. So that's the only reason why I did it, on the premise that if I don't do this, credit acceptance may say, you know what? Nah, we're not going to do it. But comes to find out, credit acceptance never had it really didn't. They didn't have nothing to do with it from the beginning. So, you see where I'm going? Where this may raise a issue of the representations of the true nature of the down payment.
Yes, I definitely understand. Yeah, so again, we have nothing to do with the down payment.
Perfect.
That's negotiated strictly between the customer and the dealership.
Perfect. There you go. There you go. Yes. Can I speak to a sales specialist, please? All right.
This call will be recorded.
See if I can trick them up right quick. Call the dealership. See if I can trick them up right quick. God damn. Oh no, they may be tied up. Let me give them a few more moments. Hurry up. Damn it. Come on, man. You got 30 more seconds. You set the stopwatch. They got 30 seconds. Hey, I don't think they take it too long, man. It's only 2 minutes. They take it too long. They take it too long. They are taking too long. Perfect. No issues there. No issues there. So, are you familiar with Credit Acceptance Funding LLC and Credit Acceptance Auto Loan Receivables Trust? For my members that's listening and everyone else, can you see how I'm directing this conversation? I'm always in control. I'm always leading the conversation where I want it to go. I don't let them. I set the groundwork. I set the framework, so we go. Yes. Hello?
Yes, sir. How can I help you?
Yes. Calling to inquire about your financing programs with regards to getting financed. Do you all work with Credit Acceptance?
We do, yes, sir.
Okay. Does Credit Acceptance require a down payment in order to finalize the contract, or is the down payment going to the dealership?
No. So basically, when we do the application, we submit it to them. They will approve you for a certain car with a certain amount down. So basically, they tell us how much you need down.
And does that payment go to them directly?
The down payment never goes to the finance company, right? The payment goes to the dealership. But the way it works is that if you put zero down, then basically they give us a turn down. So we put a down payment, let's say 500, right? We put a down payment there, and then it's approved. If we remove the down payment, it's denied. It's an algorithm that they use.
Right. It's the
with the
right.
Yes.
It's the algorithm. So basically, so basically before the contract is actually accepted, they'll throw in, all right, y'all, based on what we're gonna pay y'all for this vehicle, if they put like 1,500 down, we'll accept your contract.
Correct.
Oh, okay. Okay, so it's basically like both of y'all helping each other out. For us to sell, for y'all to sell us the
Not that we are helping each other. I mean, they give us a loan, so we have to go through them to get the loan.
Okay.
But they pretty much say how much you need down.
So much you down.
Which car you approve on as well.
Oh, okay, cool. So basically y'all already have like already an agreement like with credit acceptors. Like they already gave you an advance up front and then y'all just pay it back with the with the contracts.
No, that's not how it works.
It's not how it works?
No.
Oh.
So we don't have any. It's not like they already gave us. It's not that they already gave us anything, right? So when we do a deal with them, we send them deals. So we have different banks who work with.
Right.
So when we do the application with them and we send it to them, right? Depending on how you score with them, they say, okay, this customer is gonna need $500 down. This customer is gonna need $4,000 down.
Right.
It just depends on how you score with them. Yes.
Okay. All right. Thank you. I appreciate you. I'll be stopping by later on.
Sounds good.
All right. Ah, man. Man. Ah, man. Man. Why in the hell he gonna tell me that that's not how it goes? Huh? Did they not know who he's talking to? Did I know he's not talking to the teacher's teacher? Huh? Does he not know who he's talking to? Huh? Let me pull it up right quick. I know who he's talking to. All right. There we go. I know he's talking to the teacher's teacher. I know some people was licking at the chops. Oh, he got you, Thomas Legacy. I thought you knew what you was talking about. It didn't go that way. Right? I know some people was like, hey, see? You don't know what you're really talking about. Ha ha. Man, I'm your teacher's teacher. You think they could trick the teacher's teacher up? How many times do I got to tell you? You never ask a question that you don't already know the answer to. Oh, what the hell? Hold on, there we go. Make sure y'all can see my screen. I hope you can see it. There we go. Never ask a question you don't know the answer to. Dealer servicing agreement. In a 10-K filing by Credit Acceptance as of December 31st, 2023, the server explains in detail that the existing dealer agreement between seller and assignee is a dealer servicing agreement. In addition to defining the legal relationship between Credit Acceptance and the dealer servicing agreement assigns the responsibilities for administering, servicing and collecting the amounts due on consumer loans from the dealer to us. It's credit acceptance here. Per the retail installment contract, the dealer assigned the contract to the servicer. This assignment was due to the existing agreement, which in relevant part states, a consumer loan is originated by the dealer when the consumer enters into a contract with the dealer that sets forth the terms of the agreement between the consumer and the dealer for the payment of the purchase price of the vehicle. The amount of the consumer loan consists of the total principal and interest that the consumer is required to pay over the term of the consumer loan. Consumer loans are written on a contract form provided or approved by us. Although the dealer is named in the consumer loan contract, the dealer generally does not have legal ownership of the consumer loan for more than a moment, and we, not the dealer, are listed as a lien holder on the vehicle title. Consumers are obligated to make payments on the consumer loans directly to us, and any failure to make so will result in pursuing payment through collection efforts. Well, Thomas Legacy, that's not really saying nothing. You said that you have a pre-existing agreement, and they said, no, that's not how it works. Well, he works at them. You don't work there, Thomas Legacy. So why should we listen to you? You don't have to. Just keep reading. Also, the dealer did not show that the servicer had already advanced sums of money to the dealer in exchange for future contract receivables, consumer loans. This reiterates the position of the obligor as the accommodation party and not the borrower. In the 10K filing, the servicer said, we record the amount advanced to the dealer loan, which is classified within loans receivables and our consolidated balance sheet. Cash advanced to the dealer is automatically assigned to the dealer's open pool of advances. Like I said, you already owe on the contract on the vehicle before anybody steps in there. Every finance company has these agreements with dealer networks because they need to originate the receivables so they can pledge it. Dealers make an election as to how many consumer loans, either 50 or 100, will be assigned to an open pool before it's closed. Like I said, credit acceptance, you might got about 30 cars on a vehicle that belongs to credit acceptance, another 20 cars on a lot that belongs to Westlake, 15 may belong to this finance company through their bank, another 20 over here. So whatever, like the one I just called them, credit acceptance, right? I mean, the dealership, right? So whatever finance company that's assigned to it, at the end, your contract's been assigned to credit acceptance. Guess what? They already owe credit acceptance for that vehicle anyway, because they already advanced them funds. What did he just say? Nah, that's not how it works. Right. Did I argue back and forth with him and pull this up and read it to him over the phone? Why? All advances within a dealer's pool are secured by the future collections on the related loans assigned to the pool. Like I said, future collections, meaning somebody's going to come in and sign the contract. That's how you're going to pay us back on these obligations. Like I said, they already own the vehicle before you sign the contract. You're just taking over the debt. Peter to pay Paul. Consumers are Peter. The investors, through the finance companies, through their entities they set up, are Paul. So what did he just say again? What did he just say again? That's not how it goes. Right. I know people that own dealerships. I know people have lots. People there in my group. I know how it goes. We perfect our security interests with respect to the dealer loans by obtaining control or taking possession of the consumer loans, which lists us as the holder on the vehicle title. as the holder on the vehicle title. There's a difference between a holder and a holder in due course. It's up to what would be the answer, Shad? I mean, say, what was the word that down payment amounts to a blank of the contract? So it's up to credit acceptance as to what down payment is needed to proceed. He should know as he works at a dealership, right? It's never up to credit acceptance about the down payment. That's not how it goes. Basically, it goes like this. They send a contract up, and credit acceptance says, oh, okay, we'll accept this. Based on the algorithm, y'all should charge them probably $2,500 down payment. So let's say this $20,000 vehicle. Okay. Credit acceptance is going to say this. All right. Because you know they use the blue book value of the vehicle. They never give the dealership the actual purchase price. They pay what it's actually worth. It's $20,000 to us because they hide the interest and the fees into the principal balance. So basically, $20,000 vehicle, you get accepted with credit acceptance. They say, okay, we're going to give you $8,750 for this vehicle. We're going to give you $5,750 right now. So that means you should ask them for $3,000. That's how it goes. Credit acceptance is going to give them $5,000 and some change on it. And they be like, all right, tell them, hey, they go $3,000 up for you. All right, they need $3,000 for the close, but regardless of what, once credit acceptance accepts the contract, whether the dealership gets a down payment or not, credit acceptance ain't got nothing to do with it. They don't care. That's how it goes. Go down this road and then ask questions and let them give me the answer that I need or confirm. And this is why I asked, are you familiar with the securitization? Pretty much what I'm asking her, because there's no need for me to go down that road if she's unfamiliar. It's a pointless conversation. So I thank you, ladies and gentlemen, for tuning in to Thomas Legacy Audios, where we will provide you assistance. Call what you're about to hear is between me and Westlake Financial. Now, let me give you a little backdrop on that. Last year, financing company Westlake. So what you're about to hear now is the phone conversation, and I'm going to be talking about my equitable rights. I'm going to be talking about the investment contract, the SEC filings, and what really happens on the 91st day after you default. What really just a contract, meaning, and I I mean, I did the research, I did an audit on the contract, I did an audit on it. I could trace the money from me going all the way to Westlake to the investors who purchased the securities, which this vehicle loan file, my loan file, yes. And even you, Westlake, you are not the actual creditor. You've already assigned my loan to a automobile receivables trust. You don't have an interest in this. You've already sold it. You're not the true party of interest. You did not loan me any money, Westlake. You purchased a contract, meaning that is an investment contract. You didn't loan me the money. You had to deal with Win Rider before I even stepped in the building. So Win Rider, that's that pre-existing agreement I'm talking about, had me secure my automobile to pay its debt back to Westlake back. And that are just a few of the allegations I'm bringing up in my lawsuit against Win Rider and my arbitration. So I'm doing the arbitration on the contract, but then arbitration, lawsuit, it's all being combined in a particular venue that we go over in our class. But I know a lot of people think when I say contract, like the contract I signed, but I'm actually not going to be focusing on the contract I signed. I already said what type of contract I was talking about. Then I'm doing a lawsuit versus Blake wants to continue to enforce receivables trust. Once the loan file hits the trust. Okay.
And on the information provided me today, let me just check.
You got to know how to enforce your right. All right, here it goes. Okay, because now as far as the account, I'm requesting that y'all place it in suspension, deferred.
Lamont, thank you so much.
Hold on.
Hello, Sir Lamont. Thank you so much for your patient waiting. Sorry for the long hold.
It's okay.
So for this one, sir, as of the moment, the account is not yet eligible to defer the payment. You can give us a call on the 29th.
Okay.
Later 29th next week to check if you can file an extension or deferment.
Okay.
But just a heads up, sir, because one of the eligibility.
Right. Come on, get to it. Does Westlake still have a claim to the account, although it's really the insurance that would really have the claim? And if so, when they bring lawsuit or repossession. All right, so I brought two vehicles last year. And I didn't want this one anymore. I didn't want this vehicle anymore. So I left it at the dealership where I got my other vehicle. I left that one there and told them to pick it up. They left it on the dealer's lot for like almost 2 months. The dealership was helping me try to get them to come pick it up, and they wouldn't pick it up. And they waited. It was like 90 some days before they went to get it. And I kept calling. I said, listen, the keys are with the dealership. The lady from the dealership was so helpful. She was calling day in and day out. Like, yo, come pick it up. He said he don't want the motherfucker. Come pick it up. Drive it off the lot. So I turned that one back in. Because I brought two vehicles like in the span of a couple months. So I read the 91-day thing. Well, you'll hear it. So they waited to 91 days. And I actually got a letter written by the lady the letter written by the lady that helped me, and she got it notarized there because they got a notary there. So they've actually, there's no obligation on the account, on this Westlake account. There's no obligation. Don't show up nowhere. They just decided to just let it go. But they actually tried to play me. But if I didn't have that lady there that helped me and wrote a detailed statement, typed it up, and got it notarized, they would have tried to play me. And then I had to spank them. So there's no more ongoing dispute with Westlake anymore. They actually made the other dealership cover that. And I actually got a letter by them the other day. And I got a letter last year saying the account balance is 0. I think I went over that. It's over here somewhere. I think I screenshot it. So this, but I want y'all to hear it's a certain part I want y'all to hear.
Are they repossessing or bring gets paid out from the insurance?
There we go.
Okay. So on the 91st day of company to assume collection.
Yes, sir.
Yeah.
Hello, sorry, I don't hear anyone on the other line.
I'm right here. Can you hear me? Can you hear me? Can you hear me?
Yes, sir, I can hear you now.
Okay. So on the 91st day, the account gets 90 days past due, and Westlake gets paid out from the insurance. When Westlake continues to pursue collection efforts.
Sorry, sir, your line is cutting in and out.
Okay, I said, okay, I'm sorry. So when Westlake gets paid on the 91st day from a past due account, when the insurance company account, although it's really the insurance that would really have the claim, and if so, when they bring lawsuit or repossess, are they repossessing or filing a suit or getting a judgment or whatever? Are they doing it in Westlake's own name, or they going on behalf of the insurance company? Because the insurance company pays them out at the 91st day, meaning the account is paid.
That's an important factor right there. On the 91st day, it's paid out. Where do you think it's paid out from? I'll let you figure that one out.
So will Westlake still attempt to collect after it's already received the money on the account and the account is paid? Or will it allow the insurance company to assume collection?
Yes, sir.
Yeah.
Hello, sorry, I don't hear anyone on the other line.
I'm right here. Can you hear me? Can you hear me? Can you hear me?
Yes, sir, I can hear you now.
Okay. So on the 91st day, the account gets 90 days past due, and Westlake gets paid out from the insurance. When Westlake continues to pursue collection efforts.
Sorry, sir, your line is cutting in and out.
Okay, I said, okay, I'm sorry. So when Westlake gets paid on the 91st day from a past due account, when the insurance company pays them out, does Westlake still pursue collection efforts? Is it in their own name, although they've already been paid, or is it in the insurance name, the one who paid them out for the past due account?
Okay, actually, sir, once the insurance company paid off the account, the lien or W or Westlake Financial will be deleted on the as a lien holder.
Right there. And that's what I used to stick them.
You're rocking with the best.
I transcribed this and sent it in the audio to them. That's what I used to stick them. Right there.
The insurance name, the one who paid them out for the past due account.
Okay, actually, sir, once the insurance company paid off the account, the lien or W or Westlake Financial will be deleted on the as a lien holder.
Right there. And this is why they don't want you to get to 91 days. Because Westlake policy is, I want to wait to the. All right, so you gotta get in the Supreme League team, because then you'll see it black and white as well.
Paid off the account, the lien or W or Westlake Financial will be deleted as a lien holder.
Okay, so there'll be a new lien holder, and that new lien holder will then pursue collection efforts. Okay, they will. All right, thank you, man. I will be calling back on the 28th. If that doesn't work, when you go to a dealership, down payment, they keep that. Look at a car that costs, let's say. So basically, with it was hard to. I know y'all. It's kind of hard to hear her. But basically, what she said was 91 days. 91 days, the insurance company pays them out. Why does the insurance company pay them out and they cease to be lien holders? Why? It's because they've already cashed in the collateral which secured the receivable. Well, who is really entitled to that collateral that secures the pledge? That'll be something you will have to explore when you file suit. You can fill in the blanks from there. Pretty sure you can. Coming in, and then on the welcome, ladies and gentlemen, to another edition of Thomas Legacy Audios, where we bring the knowledge and information and research that we do and the information that we put on paper, and we are bringing it to real life situations where you can actually hear the knowledge and gauge the response for lawful. So keep that, make a mental note of that. Today's video will be dealing with a phone call to Navy Federal Credit Union, in which I'm calling in as a interested buyer in purchasing mortgage. The promissory note. This is why mortgage notes are secured by a deed of trust. This is the security instrument. This instrument is governed under UCC 8. The promissory note is also governed under UCC 8. Now, for those of you who no. Uh-oh. 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 I thought it was UCC 3. That was UCC 3. No, the notes of negotiable instrument, I guarantee you, for those who make that argument, they are just regurgitating information that they heard on YouTube or other places, because you have to understand the mortgage note does not mature until 30 years later, or 15 and 25 in most cases. That is a security under Title 15 UCC section. But I thought that, hold on. I thought it's a negotiable instrument, so I can tender a negotiable instrument to set off the negotiable instrument. I it was all governed under UCC 3. I thought it was all governed under UCC 3, right? All these teachers, man, I paid for that shit, and it's governed under UCC. It's not governed under UCC 3. So that means I'm in a totally different arena with my presentment. And I don't even realize I was in the wrong arena the whole time, because I was just following what the teacher said. Yes, that's exactly what happened. No wonder why they don't answer the phone anymore. Section 78C. So we're going to put to bed this signature created the money, you deposited the money, you loaned me the money back. That is an old modern money mechanics theory that really has no place. It's been phased out. Banks do not do business like that anymore because they have securitization. The securitization is a way for a bank to move these assets off its books to open up their lending power. Because if I'm a bank and I got 25,000 mortgages on my books, I'm stretched to my lending capacity. But if I was to sell these mortgages, I can free up lending capacity. And it looks better to investors that, I don't have all these mortgages, all these potential liabilities and defaults on my books when I want to entice them to purchase these products. So this phone call is centered around the mortgage sale of it, the recording of the title, and recording of the security interest. Because in order for a mortgage to be enforceable, it has to be recorded. Every new ownership has to be recorded. And under the accounting ASC, the Accounting Standards Board for America, and pretty much all over the world, these mortgages, in order for the remit to qualify for tax exempt status under 26 USC Section 860, there has to be at least two true sales. Now, if you look under, just Google ASC 860, this is the accounting, the balance sheets of the banks that you must be familiar with. You cannot come to the banks with this watered down misinformation administrative process that has nothing to do with the normal bank functions and runnings of banks and thinking you're going to get a remedy. You have to know their rules, the game they play, and use their rules and their playbook to your advantage. Because within every securitization, there is, a boatload of violations in which you can use to your advantage. I'm not saying you're going to get everything back scotch-free, but we're here to, the point of this is to let you know where your rights are. And what rights do you have? And what remedies do you have if your rights are violated? Will the remedy of the violation result in you getting the house back clear and free? Possibly. Could it reduce the principal balance that you owe? Possibly. All right, y'all. I gotta go because I gotta get back. I got stuff I gotta do. Got people here that came from out of town. I got my daughters here. My oldest daughter is. So I gotta go and I gotta get ready for class. But if ThomasLegacy603@gmail.com, and even if you think I got it wrong or you see it a different way, hey, shoot me an email. Let's converse. If you think what I'm saying, there's only one venue to actually handle claims, set-offs, and things like that. If you believe it's not, then shoot me an email. If you think I got it, shoot me an email. The only thing I ask, bring your facts and proof. I can't win against a belief system. I cannot win. I can't win against a belief system. I can only bring facts and evidence. You bring in beliefs, hey, you win. Because there's nothing I can say or do to change your mind. I can't beat a belief system. But we talking like facts, black and white, actual facts, like court case confirmation facts, legal publishings from the top law firms in the world, facts. Oh, yeah, you can. Ain't nobody can do with me on that level. Ain't nothing. Talk about proper interpretations. But if it's a belief or just because you feel it should go, you win. I tap out. You win all day. All right, y'all. I gotta go. ThomasLegacy603@gmail.com.
Good